Aisha Chwayo. For the state is Advocate Gaba and Advocate Twega. Representing accused number 1 or applicant number 1 and 5 is Advocate Mlochwa. Representing accused or applicant number 2 is Advocate Volmarans. Representing accused or applicant number 3 is Ms. Gilling. Representing accused or applicant number 4 is Advocate Jorgensen. Ms. Dlamini is assisting with the interpretation of this matter. Matter was adjourned today for purposes of parties to make submissions in relation to the application to be released on bail brought by all 5 accused or applicants.
Thank you. You confirm your appearance.
May it please the court to issue, I do confirm my appearance on behalf of applicant number 1 and number 5 in these bail application proceedings.
Thank you.
Please, the court, your worship, I confirm my appearance on behalf of applicant number 2.
Court, please, your worship, on behalf of applicant 3, confirm my appearance.
Please, the court, your worship, I appear for number 4, Jorgensen P, instructed by Mr. Taylor.
I need to place on record that we are only starting at this time because of the delay which was occasioned by yourselves, in that your papers were not correct, and I had to allow you opportunity to rectify your papers, which has caused a delay, and fortunately now the papers are all ready and corrected. I must also place on record that the heads of argument by the state were only sent late yesterday. According to my computer, they were sent at 2:30, at which time there was no internet. I could not access them, so I don't know what is contained in the state's papers. I could not read because this morning I had to drive from where I'm coming from to here and had to attend to the shortcomings that were there in your papers. But be that as it may, I will allow you to proceed with your submissions and engage you wherever I can in your submissions. Whilst we are proceeding with the arguments, the applicants may be seated. I will give the floor to you, Advocate Mlochwa.
First and foremost, in respect of the introductory remarks by the court, the responsibility is being owned for the mistakes that the court had to give us the indulgence. We are indebted to the court for the indulgence. Your Worship, the agreement by all parties in the matter is to the effect that, in the light of the fact that we are dealing with multiple applicants, that there will be no need to read the entire heads of argument to save time. However, one will have to draw the attention of the court to those aspects one feels are significant to be brought to the attention of the court. Your Worship, I'm not sure if perhaps it will not be more appropriate to mark all the heads of argument, or they will be marked as we are proceeding.
They will be marked as we are proceeding, but yours are creating a problem in that you have combined the first and the fifth applicants.
That is correct, Your Worship.
Yes, in one document, which would mean that I will have to mark them as one exhibit.
That is the position, Your Worship, for convenience sake.
So for applicant number 1 and applicant number 5, The heads of argument will be marked Exhibit N.
As court pleases.
Thank you. You may proceed.
Your Worship, I will shoot straight to paragraph 3 of my heads of argument. As the court has indicated that the state's heads of argument were submitted yesterday, it would appear that after traversing the state's heads of argument, one has to see some authorities to clarify further issues. So under paragraph 3, Your Worship, if the following can be added, that the Criminal Procedure Act 51 of 1977 does not contain a legal definition of bail, save to mention in section 68 that the effect of bail granted.
Sorry, Francis, where are you reading? Or where should that be added?
Your Worship, it will be added under paragraph 3,
Paragraph 3 starts by...
before paragraph 4. Paragraph 3 reads, it is respectfully submitted that the learned authors, Dutoit et al., opine that the basic purpose of bail from society's point of view has always been and still is to ensure the accused reappearance for trial, but pre-trial release serves other purposes as well, purposes recognized over the last decade as often dispositive of the fairness of the entire criminal proceedings. Pre-trial release allows a man accused of crime to keep the fabric of his life intact, to maintain employment and family ties in the event he is acquitted or given a suspended sentence or probation. It spares his family the hardship and indignity of welfare and enforced separation. It permits the accused to take an active part in planning his defense with his counsel, locating witnesses, proving his capability of staying free in the community without getting into trouble. So having read the heads of the state, Your Worship, I'm of the opinion that it will be important to add the following, that the Criminal Procedure Act 51 of 1997 itself does not contain a legal definition of bail, save to mention in section 68 that the effect of bail granted is that an accused person shall be released from custody upon payment or the furnishing of a guarantee to pay the sum of money determined for bail. In essence, the purpose of bail can be regarded as securing the attendance of the accused while balancing the interests of justice against various rights and factors. Again, Your Worship, under paragraph 4, before paragraph 5, I found it important that a reference be made in the case of, in relation to the case of Novick versus Minister of Law and Order, and another, 1993, Volume 1, SACR 194, Witwatersrand Local Division decision as it was known then, judgment by Berman A.J. on page 197, particularly paragraph F to I, where the learned judge stated that the state is not entitled to hold an accused in custody for the purpose of investigations and so frustrate his right to apply for bail. The state in that context, the relevant policeman, is not entitled to be the final arbiter as to whether an accused is entitled to bail or not. The case that I quoted in paragraph 5, Your Worship, is a well-known case of Goddard versus the state, wherein the accused was facing multiple charges of rape in this division, with complainants who were all primary school learners, where the learned judge in this division, Mungadi, stated that incarceration prior to a conviction with all its irreversible indignities and consequences may not be resorted to easily in a constitutional democracy with enshrined Bill of Rights. Otherwise, Your Worship, this other case finds relevance. State versus Smith and another, 1969, Volume 4, SA 175, decision of this division, N, at 177 page, paragraph E to F, where it was held as follows. The general principles governing the grant of bail are that in exercising the statutory decision conferred upon it, the court must be governed by the foundational principle which is to uphold the interests of justice. The court will always grant bail where possible and will lean in favor of and not against the liberty of the subject, provided that it is not, it is clear that the interest of justice will not be prejudiced. Your Worship, I think it is important to jump to the additional reasons why bail should be granted. That will appear on page 7 of my heads of argument. Your Worship, it's common cause that before this honorable court are the founding affidavits by both the first applicant and the second applicant in paragraphs 212, 213, 214, where there are reasons given for why bail should be granted. After receiving the state papers and going through the state papers, Your Worship, particularly the paragraphs in the opposing affidavit of the state 212, 213, 214, and the heads of argument that the state has submitted, Your Worship, there is no denial that the possibility exists that before the matter can be set down for trial, the other processes will have to come full cycle, the extradition as well as the mutual legal assistance. Your Worship, it is in that context that paragraph 14 is stated that, it is stated that in full compliance with brevity is the soul of the wit. We are talking about the inference that one is able to draw. So it is another reason that the bail application ought to be granted, especially because even if the court outside this jurisdiction, the requested country, that is Eswatini, even if it grants the order to surrender, those alleged fugitives will still be entitled to appeal. Your Worship, the allegation in paragraph 18, the allegation that the applicants will not stand trial, Your Worship, it ought to be, the allegation by the state ought to be considered in the context that in respect of applicant number 1, he became aware in December 2023 when he alleges that upon his arrest, it was brought to his attention that the police will eventually arrest him in connection with the death of the deceased number 1 in this matter. So up until he was arrested at the police station, complying fully with the order of the learned magistrate, Mr. Singh. Your Worship, this allegation
Sorry, how can you say he was complying fully with the order of Magistrate Singh when the evidence is that he was looked for at his residence, he could not be found. That is why he had to be arrested at the police station, and later he took the police to Nzeleni, where some of his belongings were found.
Your Worship, I fully understand the court's concern. However, my humble submission, Your Worship, to the court's concern is that the concern also arises in the evidence of the investigating officer to that effect. If one looks at the affidavit that was filed, presented before the learned magistrate, Mr. Singh, the investigating officer was able to interview the parents of applicant number 1, the mother, the father, as well as the siblings, for him to say personal circumstances have been verified. This time around, Your Worship, the concern is the investigating officer is making that allegation without taking the court into full confidence. Who exactly did he speak to? Who would have given that information to him? If in the initial bail application he is able to interrogate and interview the parents, what is it that would have prevented him this time around not to do that? So my humble submission, Your Worship, is that the evidence of the applicant ought to be accepted in that regard. And again, Your Worship, the legalities, the constitutionality of the issue, of the explanation, no explanation of rights, no indication to applicant number 1, whatever he says may be used against him at a subsequent court proceedings. I think, Your Worship, that is also a concern. My humble submission is, had the investigating officer approached his parents would have confirmed. The police station would, the register was not even challenged that he was signing at the police station, that he was complying fully with the order of the learned magistrate.
New Iliadin Aloe works fast to provide relief that lasts up to 12 hours. Try the new Iliadin Aloe today.
But yeah, I hear you in saying that there was maybe constitutional issues, explanation of his rights and what have you. Now the question that comes to mind is how would the investigating officer have known of Nzeleni address had the accused not supplied that address?
Your Worship, that is the allegation we make in the replying affidavit, the reliance upon the informers. It's possibly that somebody purporting to be an informer would have tendered that evidence to the investigating officer. It is against that background, Your Worship, that had the investigating officer at least obtained the statements to which people he got the information that he was no longer residing in the area were stating when they got that information and what circumstances and so on and so forth. And Your Worship, the standard in these proceedings is just on an honors, it is just on the balance of probabilities. Your Worship, in respect of paragraph 19, I think paragraph 19 of my heads of argument ought to be looked at in conjunction with paragraph 36 of the state's heads of argument. Starting with the state's heads of argument, in paragraph 36, reference is made to the case of State versus Kitticat. I assume, Your Worship, all of us has cited that case as it is locus classicus from the Apex Court. What I'm trying to draw to the attention of the court, Your Worship, is that the state is saying the court held that bail proceedings are sui generis. I fully agree. The application may be brought soon after arrest. Your Worship, my humble submission in that regard is that this case is distinguishable from the Skitticat case in the sense that the alleged incident dates back to February. There is a huge time lapse between the arrest upon all the applicants and the alleged incident. And if the state is saying the investigations are incomplete, Your Worship, again there is concern in the sense that the state is just generic. The state is not taking this court into full confidence in terms of particularizing in the light of the time lapse between the alleged incident and the date of arrest. What is it that is still outstanding? Is it the money laundering charge? Is it the assessment and the analysis of the forensic evidential material? That is not coming from the state, except that the investigations are incomplete. It is on that basis, Your Worship, that reference is made to the case of Moi in paragraph 19, where the learned Judge Snyders, J.A., held that the delay by the state in concluding its case, taken with the accused witnesses of state case, constitute exceptional circumstances which, in the interest of justice, permit the release of the accused. In other words, Your Worship, it cannot be an excuse. This is a high-profile matter. It cannot be excused that after more than 12 months of the alleged incident, when the arrest is executed upon the people considered to be connected with the matter, there is a wild allegation without particularizing the investigation.
Let me understand you again. Are you saying it is the state submission that the investigation has not been finalized? Outstanding?
Your Worship, probably it will be wise to refer to paragraph 266 of the answering affidavit by the investigating officer, Mr. Pillay, wherein he states as follows: the investigations in this matter are at an advanced stage and very strong against the applicant. My team and I took a long time to investigate this matter prior to arresting the applicants in order not to delay the matter further after arrest. This approach has yielded the results because the investigations are advanced. In a nutshell, Your Worship, it is clear, and again in the heads of argument by the state, it is clear that even if the judgment were to be handed down in this matter, the matter will not be set down for trial immediately, as there are still investigations that are ongoing.
Well, but does this say there is outstanding investigation? The investigation are in advanced state.
Yes, Your Worship.
Okay. What does that say?
Investigations are incomplete.
Yeah, okay.
My instructions, Your Worship, it just says that, as the court has correctly pointed out, investigations are at an advanced stage, but it doesn't say the investigations have come full sight, are complete.
This makes one speculate. Could it not be not finalized because there are accused who are still outstanding, who are still to be extradited from Eswatini? I'm not here for the state, but I'm just asking because that is a fact.
As the court, please, Your Worship, presumption is everybody is able to articulate himself. If that was the position, Mr. Pillay, the investigating officer, would have stated exactly in those clear terms. That it goes back to the concern that I've raised, the generic allegations.
Yes.
It would have helped all of us if the state was able to take everybody into full confidence and tabulate, this is X, Y, Z that is outstanding. For instance, if there is an allegation of a money laundering, probably one will think of a forensic audit report. Somebody would expect perhaps the DNA to be outstanding. So under normal circumstances, it is the practice in our bail applications, Your Worship, where the state will take the court into full confidence and say, investigations are at an advanced stage, however, outstanding is the following. It doesn't help to just generically refer to the investigations as just as being at an advanced stage.
Whilst we are on that, you are saying, citing Moy versus the state on page 10,
Yes.
that Snyder J.A. held in Moy that the delay by the state in concluding its case, taken with deduced weaknesses of the state case, constitute exceptional circumstances. What do you mean, weaknesses?
Your Worship, as I progress with my submissions, at a later stage I will be demonstrating to this court the impeachability of the charges that the state has preferred against the accused when we talk about the state case. Obviously, with the Moy case, as well as this honorable court, will have to adopt a holistic, expansive, integrative approach, looking at all the aspects, and then in the context of Scott Crossley, individually and cumulatively, make a determination whether exceptional circumstances have been presented or not.
Well, I'm asking this question at this point in time because in your founding affidavit, you say that the applicant number 1 will apply for discharge in terms of section 174 of the criminal procedure during the trial. It is on those bases that I'm raising this question.
Not only that, Your Worship, an averment to the effect that the state is clutching at straws in the affidavit. Probably, Your Worship, let me quickly address the court under the state case subject to serious doubt and non-existent in paragraph 28 of my heads of argument. Okay.
Yes.
Paragraph 43. Where is that cover sheet? This is interesting. Okay, my apologies. Your Worship, if one were to understand the attack on the state charges, if one looks at the state heads of argument, paragraph 61, the state submits as follows. On the charges of unlawful possession of firearms and joint possession principle, the High Court of this division has recently pronounced on same and convicted the accused on those charges based on the principles as indicated on Exhibit G. That being the case, Your Worship, at the back of our minds, we have got how the attack is crafted in the founding affidavit and the heads of argument. First of all, the issue of duplication of the charges, the splitting of the charges, in respect of the first two counts, conspiracy to commit murder and murder. I pause there. Your Worship, the greatest advantage we have is that this honorable court has been sitting in the court of first instance for years. Invariably would have served the indictments on the accused who would have been transferred from the court of the first instance to the High Court in terms of Section 75, subsection 2. That being the case, this court would have observed the practice in the division of making those two counts, the main and the alternative count, not separate counts. So, if you look at the two decisions that the state has submitted, State versus Gabash, two accused were involved before the Honorable Acting Judge Hlachwayo. My learned colleague for the state, Mr. Gwega, was prosecuting conspiracy to commit murder, and then unlawful possession of firearm based on joint possession doctrine. The learned judge granted 174 in respect of accused number 2. And if you look, that will be in paragraph 17 of Gabash. So which means the matter proceeded beyond state's case in respect of accused number 1. Those two counts, and then at the end of the day, the learned judge, Hlachwayo, convicted on murder and possession of firearm and ammunition. Interesting in that case, the learned judge, Mr. Hlachwayo, stated that the state, my learned colleague, Mr. Gwega, was able to present evidence beyond reasonable doubt that accused number 1, that will be Mr. Gabash, is the one who was in physical possession of the firearm. However, the state failed to prove the second leg. So that submission, Your Worship, it addresses the conspiracy to commit murder and murder, as well as the issue of the joint possession of firearms. Your Worship, it is on that basis that in paragraph 30, a history has been given tracing the principle on the splitting in respect of those two counts. Paragraph 30 of my heads of argument. It is particularly paragraph 30.1, where I state the following. The diachronic approach makes it clear as a day that archaic is sacrosanct criminal law principle of splitting or duplication of charges. Accordingly, conspiracy to commit murder and murder, count numbers 1 and 2, constitute splitting or duplication of charges in this matter. The learned author, C.R. Snyman, in criminal law textbook, defines conspiracy as an inchoate, formally defined crime, whereas murder is a complete materially defined crime. Hence, more often than not, the rule of practice is that the former is an alternative to the latter. 30.2, however, the criminal law principle of splitting or duplication of charges, particularly in respect of conspiracy to commit murder and murder, has long been enunciated and put to rest by the Supreme Court of Appeal, first in R versus Min and Ailey, then State versus Fraser, and most recently in State versus Nongogo versus the state, in bracket, that would be in footnote number 31, the full citation, open bracket 852/2020, close bracket, open bracket 2021, ZASCA 166, paragraph 3. The application for leave to appeal was granted against conviction and sentence on conspiracy to commit murder and murder by Mjali in Nongongo. This case, Your Worship, it emanates from Umtata. And then on appeal, Nichols, J.A., Wilsaldaka, 8AP, and Mochumi and Mohoshwa and Govan, J.J.A. in the Supreme Court of Appeal concurred that the state had correctly considered that the applicant should have been convicted of either murder or conspiracy to commit murder, but not both. This is the Constitution, the SCA. This was explained in State versus Fraser. Normally, where a person conspires with another to commit a crime, and the crime in question is committed, then the conspirator is liable for the crime itself and should be so charged. A reference is made to Puchel. Then the charges continue. This concession is well made, and therefore, the appeal on duplication must succeed. And Your Worship, the second case of Lopes